Prakash Singh vs. Union of India 2006. How should the police do the duty? What are the reforms needed? Prakash Singh judgment issued 7 binding directions on police reforms. The Supreme Court recalled its observation in Vinit Narayan case regarding the need for police reforms. Background: Policing in India is governed by the Indian Police Act 1861. Despite radical changes in the political, social, and economic situation in the country, there was the absence of any comprehensive review at the national level of the police system. On 15 November 1977, the Government of India appointed a National Police Commission. The commission was appointed for the examination of the role and performance of the police, both as a law enforcing agency and as an institution to protect the rights of the citizens enshrined in the Constitution. After a detailed examination of various issues related to the police system in the country, the Commission submitted its first report in February 1979, second in August 1979, and 3 reports each in the years 1980 and 1981, including the final report in May 1981. However, the recommendations of the National Police Commission were not implemented. In 1996, Prakash Singh, former DGP of Uttar Pradesh and DG of BSF, filed a writ petition in the Supreme Court under Article 32 of the Constitution, praying for issue of directions to the Government of India to frame a new Police Act on the lines of Model Act drafted by the National Police Commission, in order to ensure that the police is made accountable essentially and primarily to the law of the land and the people. Arguments: The petitioner stated that the violation of fundamental and human rights of the citizens are generally because of non-enforcement and discriminatory applications of the laws. According to the petitioners, the present distortions and aberrations in the functioning of the police have their roots in the Police Act of 1861. The petitioners submitted that the commitment, devotion, and accountability of the police have to be only to the rule of law. According to the petitioners, sought a direction to the Union of India to redefine the role and functions of the police and frame a new Police Act. The petitioners also called for the separation of investigation work from that of law and order. The judgment: The Supreme Court recalled its observation in the Vinit Narayan vs. Union of India. In that case, the court observed that there is an urgent need for the state governments to set up the requisite mechanism and directed the central government to pursue the matter of police reforms with the state governments and ensure the setting up of a mechanism for selection and appointment tenure, transferring and posting of not merely the chief of the state police but also all police officers of the rank of superintendents of police and above. Under Article 32, read with Article 142 of the Constitution, the court issued the following directions to the central government, state governments, and union territories for compliance till framing of the appropriate legislation. First, the state governments are directed to constitute a state scrutiny commission in every state to ensure that the state government does not exercise unwarranted influence or pressure on the state police. Second, the Director General of Police of the state shall be selected by the state government from amongst the 3 senior-most officers of the department who. Next, the investigating police shall be separated from by the law and order police to ensure speedier investigation, better expertise, and improved rapport with the people.